May I place your lordship?
1 second.
May,
Just 1 second.
At this proceeding, but I am appearing on behalf of the major Milord Industry Association, which is the ASSOCHAM, Fifty Milord, and CI. But we have filed applications today morning. Lord,
If the application is not numbered, it is not registered, we'll follow what sauce for the goose is sauce for the gander. Mr. Rodhi, sorry, no oral mentioning in my court.
No, I'm not, Milord, I'm in the matter I am saying. I am saying.
We have no such application on board. Let it be circulated. We'll deal with it in the normal course.
But Milord, I am respectfully submitting. If
Sorry,
you
appearing for big clients, we will not tolerate this. You have to follow the rules in my
But
court.
Milord, if you Lordship make an order today, my application will be infructuous. I am saying kindly defer the issue of grant of alphanumeric.
Mr. Rodhi, you are aware of what proceedings were going on. You could have intervened at that stage. What is this after the judgment is passed? You want to intervene now?
Milord, the order is of 15th March. Ask
No, but you are aware about the proceedings pending before this
But
court.
Milord, we were not parties anywhere. We were not parties at any time.
Everybody, the whole world knew that this matter was being heard.
Milord, I have
Come
no.
back 1 second, Mr. Rodhi. You come here after the judgment is delivered. You are now, you file an application. That's not the way.
Milord, I have come only in regard to
Circulate and-
15th March. Kindly appreciate.
No, Mr.
I have no problem in
Rodhi,
declaration
you-
of the list of donors or the list of recipients.
Mr. Rodhi will not hear you right now. We have a specific application which is on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a, we'll get it. No.
I am saying
No,
kindly. Milord,
If I do it for Mr. Rohatgi, senior
No, no,
counsel, then Mr. Rohatgi, you look at me. As Chief Justice, I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What sauce for the goose is sauce for the
I am
gander.
not mentioning, I am not appearing in the matter and making a submission.
We have no such application on board before us.
Milord, I have got it with me.
I've made myself.
my lord, the entire,
I have emailed
entire judgment
1
has.
second, you wait. One at a time. Sorry, Mr. Rodhi. Yes.
No, my lord, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute recidicator. This judgment doesn't constitute recidicator.
1 second.
Yes.
1 second.
This
1
judgment is
second.
void.
Please listen to me. You are not, 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No, my lord.
File an application. What I told Mr. Rodgi applies to you.
No, my lord, the question is, my lord,
There's no question you got.
My friend has come.
Mr. Nedumbara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No
my lord,
further.
we will go by what your lordship.
All, please.
Whatever your lordship says, we will go by that.
Do you want another contempt notice?
No, my lord, your lordship will go by
You have
whatever
had
your
enough
lordship
to
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't constitute. It is not a representative.
Do not, please, once we have said no, please move the application by email.
What your lordship says.
Do not continue and persist.
Yes. I only said it was not a representative proceeding.
You are
All the way coming from Kerala.
You are obstructing in the administration of justice.
Pardon, my lord?
You are obstructing in the process of administration of justice.
The entire judgment is against behind the back of these people. Parliament has been rendered irrelevant.
That's all. That's all. We heard that. Please, that's all. You made it.
We are in a democracy.
We will not hear you till you follow the procedure prescribed.
We are filing it.
Please do.
We are filing it.
Please do. We'll consider it afterwards.
That's at 10 o'clock. My friend came from Kerala to took a 1 o'clock flight. Be kind to us. Be kind to us.
That's all, please. We will not hear that.
Democracy.
Please call for the application. Please follow the application.
My lord, may I mention, my lord, my petition for so moto that is pending. Whatever lordship want to do, that do only. I will not disturb lordship.
Mr. Agarwala, apart from being a senior counsel, you are the president of the SCBA.
Yeah.
You should know the procedure. You have written a letter to me asking me to invoke my suo moto jurisdiction.
Yes, my lord.
No locus to mention
So
anything.
that I should not disturb lordship. We should not waste it honorable time, court's time.
Fair
That's
enough.
why.
Lord,
Only that.
These are all publicity-oriented stunts. We will not permit it.
Handmade of a.
Whatever lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful. Please close it.
Members of the bar who are senior to your lordship.
It is enough now.
Also senior to your lordship.
It is enough.
65-year-old man, Lord.
Be kind to us, later. We are very polite and begging with your lordship. The lordship has use a soft language.
Tripura, we have been telling you that you are interfering, you're obstructing us.
No.
Now,
Look at this, sir.
if you don't stop, we will have to.
when we are not heard and we feel threatened. Sorry, Lord.
Follow the line.
Yes, Pala. Yes, hearing now. We issued notice on the last occasion to State Bank of India. Mr. Kapoor, you are appearing? You are appearing for
I
the,
appear.
Mr. Salve is also there.
for the State Bank?
That's right.
Yes.
But I appear for the State Bank.
Yes. Mr. Salve, in
Yes.
our order which we, in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So,
But I,
let SBI not be selective in the disclosure of details. We intend
But I-
to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
But I just, whatever your lordship say, if your lordship say bond numbers, you can disclose the bond number. There's no problem.
But tell us
Somebody
one
can
thing,
screen them. And
why has the SBI not disclosed?
I wanted to tell my lord how we understood your lordship's judgment. Give me 5 minutes only to explain our conduct. We'll, of course, if your lordship say give anything more, everything will be given. But there's no question.
SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
My lord, how we understood.
The SBI requires, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, I mean, State Bank of India has the best legal advice open to it.
May I, my lord, take your lordship through the 3 orders, so how we understood them? My lord, your lordship's first order was 12th April 2019.
Sure.
And we have, for convenience, my lord, we have put the 3 orders together. Your lordship just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, my lord, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order in paragraph 16, but I had asked my friend to make a little compilation of the orders so we could show them easily. Your lordship has not
Yes, para 17, right?
para 16, my lord.
16. You got this?
Yes.
Yes.
This is the interim order my lords had been pleased to make. After my lord noting all the changes, the court would have to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same ensures adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require.
Can we just see para 15 again, Swan?
Yes. The court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same would ensure adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donation through the electoral bonds to submit to the Election Commission of India and seal cover detailed particulars of the donors against each bond. The amount of each such bond and the full particulars of the credit received against each such bond, namely the particulars of the bank account to which the amount had been credited and the date of each such credit. So, my lord, your lordships felt this would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so and so, that gives the requisite
Salve, we
details.
take it you're not arguing a case for a political party, right?
No. On the contrary,
Appearing for the state
I'm saying the reverse. I'm so sorry. I'm saying the reverse. But if a political
Para 16, Mr. Salve, was relating to the political parties who had to submit the data to the
correct,
to the election commission.
correct, and they have, and this has
No, that's a separate issue. Whatever they have declared or not declared, that's a separate issue. But as far as the judgment of this court is concerned, because you were
Yes.
also supposed to.
I'm coming in a minute. If your lordship will just give me 1 minute, how we understood it. Para 16, with as my lord has therefore noticed, only required the political parties to give all these details. And these details have been given, my lord. If they have not been given, that's between the ECI and the political parties. As my lord, the Chief Justice said, I'm not appearing for a political party. 10, my lord, para 17 was the mechanism. Your lordship said details will be furnished in respect of electoral bonds, the details of such bonds that may be received by a political party. Up to a date for issuing such bonds as per the ministry, that is February 19, will be submitted on or before 3rd of May 19. The seal covers will remain in the custody of the ECI. So, my lord, we had no role to play. Your lordships had put this mechanism in place. In your lordship's judgment, your lordships dealt with the diverse aspects, including the need to preserve some degree of anonymity, and your lordships will not mark that in para 125, where your lordships discuss the electoral trust as an alternative to this system. And in the conclusions, which are at para 218, if your lordships have the compilation, it would be PDF page 76.
Yes.
Your lordships will not say we direct the disclosure of information on contribution received by political parties under the electoral bond scheme to give logical and complete effect to the ruling. On 12th April, the court issued an interim direction order directing that the information of donation received from donation must be submitted by political parties. The court directed political parties to submit detailed particulars of donors against each bond, the amount of each bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date on which such credit has been made. I'm only not saying this to explain how we understood the order. So this correlation between which political party has received money from whom comes in here, because the political party says, I have received so much money from so and so. Then it says, during the course of hearing, Mr. Sharma said that the ECI has only collected information on the contribution made in 2019 because of para 14 indicates direction was limited to contributions in that year. Your lordship then clarify para 13 and 14 of the interim order are extracted below. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission and sealed cover particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date of each such credit. The details will be furnished forthwith in respect of electoral bonds received by a political party till date. The details of such other bonds as may be received up to the date fixed for issuing such bonds, including February 19, May 19, will be submitted on or before May 19, and the seal covers will remain, etc. Then your lordships clarify, para 14 does not limit the operation of 13. 13 contains a direction in unequivocal terms to political parties to submit particulars of contributions received through electoral bonds to the ECI. Para 14 only prescribes the timeline for the submission on the contributions when the electoral bond should be done. In view of the interim order, the ECI must have collected particulars of contributions made to political parties through electoral bonds. In view of our discussion, the following directions are issued. The issuing bank shall stop issuance of bonds, which was done immediately. The SBI shall submit details of the electoral bonds purchased since the interim order by the court till date to the ECI, fully given, Details shall include the date of purchase of each bond, the name of the purchaser, and the purchaser of the bond and the denomination of the electoral bond purchase. All these details are given. SBI shall submit details of the political parties which have received contribution through bond since the interim order till the date of the ECI. SBI must disclose each electoral bond encashed by the political parties, which shall include the date of encashment and the denomination of the bond. Now, Lord, as we therefore understood this, the political parties have come and said, we have received so much from so and so. Are the details which we will give will make the database complete so that we have the who purchased, when he purchased, and when they have got. If the numbers are to be given, we'll give them. There's no problem. So, according to us, the data.
Mr. Salve, I have a few questions. First,
Yes.
tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, Malad, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time we were directed to preserve anonymity, including we had to take measures that within the bank.
What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you
In
store
two
it?
silos. Your Lordship noticed that in the next order. So the data is maintained in two
Actually, you store
silos.
it in 3 silos. From your application, it emerges now that you do it in 3 silos. The first silo is the bond number. The
Bond
second
number is
silo
only on the bond.
purchase, and the third is the redemption.
My Lord, bond number is only on the bond, and it is cannot be read except through under a UV light. That was only done, my Lord, like authentication, like because it was a bearer bond. That's what was sought to be
What's the purpose of the alpha? And second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
A
it
security feature entirely?
in the audit trail? Do you also
No, my Lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question.
Yes.
How does the redeeming branch
Yes. Yes.
match the electoral bond number to determine that it is not a forged bond?
So they were not, that's what I'm saying. When they received it, the person encashing it gets it, he sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it,
Yeah.
the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's
it,
nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the
a currency note.
alphanumeric.
Yeah. But
Cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
My Lord, you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No. That's what I'm saying. That correlation was not kept. For the reason, it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is nothing near Lordship's order. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in the. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
My Lord, even in the final judgment.
Say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
My Lord, your Lordships.
All details.
That's why we came to my Lord.
Mr. Salve will clarify to put it beyond any.
No problem. No problem at all.
We will say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains. But
you have to disclose all details. Let there be because the burden should not lie upon the court or the petitioners to say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem. Just that this constant, Malad, the media constant beating down and the petitioners giving public interviews saying, we will take the State Bank to task and we will show this and we will haul them up for contempt, etc., etc. But we are also public institutions working in this space. And it's all right. People work, people acted on the faith of this. Your lordships granted an interim order saying keep records. It wasn't at that time, my lord, subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your lordships are at that balancing interim order. Now, whether completely you should lift the privacy or remove anonymity, better your lordships will.
Mr. Salve, the idea behind the interim order was, in case a writ petition is allowed, then
Yes.
data should come out. And that's what exactly is required. Nothing
My
more.
lord, I must say so, my lord, as out of whatever my lord, the Chief Justice is saying, your lordship will clarify. We will give every bit of information, relevant, not relevant. We'll give every bit of information which we have. So that, my lord, there should be no feeling that SBI is interested in somehow holding something back. I only want, my lord, to share one thing. My lord, your lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing the lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and my lord say, give the bond number, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so and so, investigate so and so. That is, I don't think, the purpose of your lordship's judgment. That was not what it was meant for. And your lordship will see whatever safeguards need to be put in place.
Just one more
Lord,
thing.
I have 2 minutes, my lord, if your lordship permits. But at the outset, my lord, on behalf of the central government, I completely disassociate myself with what Dr. Agarwala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, my lord, on behalf of the central government. Now, my lord, I have something to share, and I have been watching this very painfully, my lord, outside the court. My lord, your lordships sit in kind of a silos. Your lordships are, my lord, in an ivory tower, not, my lord, in a negative sense of the term. But what we know here, my lord, your lordships never come to know. The way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country. But what has happened is, my lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy and we could not persuade your lordships. Lord, your lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your lordship wants is not, my lord, kind of a witch hunting. Earlier, my lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my lord, the witch hunting has started, my lord, at some other level, my lord, not at the governmental level. The application comes of the SBI before your lordships on 11th of this month, my lord, and your lordships also, my lord. That's how, my lord, we understood, clarified the position. But most serious things, my lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, Lord, a non-level playing field. My lord, on this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a series, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. My lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, my lord, any kind of my lord, posts are being made. I know, my lord, your lordships cannot control them. The question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control. Lord, that saying Mr. Rohgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of para 221.
That's
As judges, we decide according to the Constitution.
correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm
We
not,
are-
my lord,
we are-
for a
our
second saying.
court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter, this started in a very systemic.
Already. What order?
We just,
One fact.
can I assist you? Lord?
No, Mr. Rodgi, we don't need assistance right now at the conclusion of the matter.
Just
One
give me a
fact,
minute, Lord.
one fact.
I am the person who's going to. be
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we'll not hear you when your application, we have to follow procedure in the court. It's a constitutional court.
One will allow
Yes,
us.
Mr. Rodgi,
Say
no,
something.
Mr. Rodgi. I told you the reason for it. We are now at a stage when the
I am
judgment
not
is.
on my application, not that it become infirmary. I am now
Sir,
only saying
No,
that.
Mr. Rodgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party
I
assistance.
meant not.
Your lordship didn't get a
One
proper
second, please.
assistance.
So just one
The
thing.
grievance of those who will now be deemed that you have given to A party, you have given to B party, that will be.
Lord, one more clarification.
What we did that we gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition.
No problem in.
Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court.
Absolutely.
And that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization of B?
Answer is yes.
The answer is yes, not that I can't tell you.
Lord, only one line, my lord.
Yes,
Only one line, my lord. Mr. Bhushan may, my lord, now hold his horse.
Pursuant to your.
He has done, my lord, substantial assistance. I don't have to formally disassociate myself with today's mentioning, my lord. That my disassociating from Mr. Agarwal doesn't mean that I am.
Mr. Solicitor, irrespective of
Yes, my lord. Yeah, but maybe treated as well.
We must just tell you that we respect this very responsible approach which the Solicitor General has adopted of, because, clients apart, who you are representing apart. The
It is
institution has
really
to stand
painful,
above-
my lord, when the people before the court start, my lord,
Thank
a
you
media
for-
campaign
thank you for
to
saying that.
embarrass the judges.
Thank you for saying that you
It's
don't
very, my lord,
associate
painful.
with the mentioning. Thank you for saying that you don't associate.
Because
with the
there is no level playing field. I can't hold a press conference.
So, Solicitor, unfortunately.
Only grievance is that it was not a justiciable issue. Yeah, Solicitor General did not raise it. It is not a matter of pure policy. I read the entire judgment. It was entirely a policy issue. It is not justiciable at all. That's all I want to say. The people of this country feel that a decision was taken behind their back. When the parliament decides, they were present in the parliament. It is with their consent. When your lordship decides, we are.
Last order, the election commission has put out the sealed covers but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into
No,
all
but
that,
because-
Mr. That's
because-
not our remit at all.
No, I-
Yes, what has happened after the judgment is not something we are concerned
Not
with
after
at
the
all.
judgment. What I'm saying,
Now-
no, what I'm saying is this, that since the order of the,
Very recently, I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. It is the property of the nation. And,
no, I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the Election Commission, only a few of the political parties, the smaller regional political parties, some of them, have disclosed.
He is not
the names of
addressing
the
your
donors.
lordships, he is addressing somewhere else. Kindly hear him for some time. So that it comes, my lord, in the newspaper tomorrow, that Mr. Prashant Bhushan vehemently said this. That's the purpose.
Solicitor, unfortunately,
something.
public interest litigation have now become publicity interest litigation.
It is publicity interest litigation. It is, my lord, there are some hidden agendas. There is no doubt, my lord, and I am not, my lord, apologetic in saying that.
I am astonished.
And my lord, that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
Lordships, in your lordship's majesty, would not know, my lord, what are the hidden agendas behind it.
Just dictate a short order. I think, we are unnecessarily expanding upon the remit.
Because the major political parties have not disclosed the donor.
Just give us 2 minutes to dictate the order.
Therefore, what all that I am requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order,
They have filed an
Mr. Ansari, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes.
Right? In our interim order, we said that the disclosure shall be made with effect from the date of the interim order,
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitutional Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the judgment.
So the only reason why I'm saying that
in paragraph 200 in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2024.
just one fact by way of information.
Enough of assistance by this public-spirited person, my lord. Your lordships doesn't need any further assistance.
The details of the number of bonds shown by the in the data.
He is gathering the details for a future PIL, my lord, so that remains in. He remains relevant.
Now, please permit the bylaw the chief to dictate the order.
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores, and the amount redeemed is 12,769 crores, that is 550 crores more than what were purchased. Now the explanation for this could be because the data is from 12th April. At that time, the bond purchase was going on. On 12th April 2019, it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019, but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, Malad, these figures are not authentic. I've given the authentic
18,000 versus
roughly
Sponsored
22,000.
NGOs are, my lord, fudging the figures and bringing their own. My lord, your lordships are aware, there is a beautiful, my lord, quotation by Einstein that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that 18,000.
And this is what happens.
Right, we'll now leave it at that.
Those numbers are not right, since, because all this is going to play out, the numbers are not right. The corrected numbers were not given in our application.
वो अलग order pass कर देंगे. इसमें MA में ऐसा लिख लीजिए. In subpara B and C of paragraph 221 of the judgment of this court dated 15 February 2024, the direction to the SBI to submit details of bracket 1, the electoral bonds purchased, semicolon, and bracket T2, political parties which have received contributions through electoral bonds is specifically since the date of the interim order dated 12 April 2019. Stop. In other words, all details which have been directed to be furnished in the operative directions of this court are with reference to the interim order, are on the basis, don't say on the basis of, are with effect from the date of the interim order, namely 12 April 2019. Full stop. The relief which has been sought in the MA for predating the point of disclosure would amount to a substantive modification of the judgment and hence cannot be dealt with in a miscellaneous application. Full stop. The miscellaneous application is therefore not maintainable and is accordingly dismissed.
But I want one more relief to prevent another round of contempt proceedings. Would your lordship just for a minute have my affidavit in compliance for it?
What is it that you want clarification?
Yes. Maharaj, there was, when we gave your lordship, that's why I can see all this story has started. When we gave your lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your lordship just sees para 4 and Maharaj, everything will be over because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second. Maharaj.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Maharaj. There is no mismatch, there is nothing of the sort. The total, if your lordship sees the table.
Not going to all that. I mean,
No, I have to convince my lord I have complied with the order. I'm just saying.
It's a compliance affidavit. It's a compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the judgment of this court dated 15 February 2024, this court directed, into inverted commas, this court directed, into inverted commas, the disclosure of information on contributions received by political parties under the electoral bond scheme to give logical and complete effect, into inverted commas, complete, to the ruling. Full stop. Thereafter, in paragraph 219, this court issued operative directions. Of these directions, in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit details of the electoral bonds purchased since the interim order dated 12 April 2019, into inverted commas, till date to the ECI, into inverted commas, complete. Such details, the court has indicated, into inverted commas, shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased, into inverted commas, complete. In the second part of the operative direction, in subpara C, SBI was required to submit, into inverted commas, the details of political parties which have received contributions through electoral bonds, into inverted commas, complete, since the interim order dated 12 April 2019 till date to ECI. Full stop. SBI was required to disclose details of each, underline each electoral bond encashed by political parties, and to include inclusive of the date of encashment and the denomination of the electoral bond. Full stop. The above narration and a plain reading of paragraph 219 of the judgment dated 15 February 2024 indicates that SBI was required to submit all details, both in terms of the purchase and in terms of the receipt of contributions. Full stop. The expression, to invert commas, include in both subparagraphs B and C clearly demonstrate that the inclusive part was regarded as illustrative and not exhaustive of the nature of the disclosure which was to be made by SBI. Let's stop. In other words, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include this we clarify would comprehend the alphanumeric number of and the serial number, if any, of the bonds which were purchased and redeemed. Full stop. The application, this was on your application, I think you had moved this, no? The application was by the Oh yeah, we had it. Therefore, Mr. Harish and Salve, learned senior counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the chairman and managing director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date daldo.
Could we have one more day on Thursday?
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
Even to the Election Commission.
In terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details forthwith on the communication by SBI.
My Lord, I had directed, my Lord, the senior official of the bank to remain present. My Lord, the Deputy Managing Director and Chief General Manager are present here. The presence may be recorded. They both are.
Fair.
Also, so. Okay. Just 1 second, I'll let you know. Yeah, we're live. Hi, good evening, everyone. This is Kritika Goyal, and I was rank 1 in 2023 exam of the Supreme Court clerkship exam. And I've done this session with LiveLaw Academy previously, once before. And here we are with part 2 of this exam, and we'll be focusing on paper number 2 of the exam this time. The exam is on 10th of March, this Sunday. I know it's a little delayed, the session is a little delayed, but I promise I'm going to make it up to you today. And I hope you've all checked your centers and your admit cards are out. And you're all set. You're all set. And I hope that you guys are only revising at this moment and at this time. And let's just dive into it. And I'll just share my screen. Okay, so welcome everyone to the session once again, and let's begin. I'll just talk briefly again about part 2 of the exam, and it's going to be a 3.5-hour exam, and which is inclusive of 30 minutes of your reading time. So 3 hours for writing and 30 minutes is reading time. In the previous session also, I had suggested that in the 30 minutes, utilize that time in figuring out what answer you'll be writing in your question number 3 of part 2 of this exam. Okay, don't waste your time in going through the brief, because today we'll be going through question number 1 and 2 most probably, and I'll tell you how to reduce your time of reading and how to figure out how to write and everything. Okay, so it's going to be a 300 marks question, 300 marks paper. So a brief synopsis or a précis, we'll be focusing on this question number 1 today. And it should not be longer than 750 words. The brief that I've prepared is of 490 words. I'll show it to you after in a while. And 2 sides of a single page, approximately, I think that's how long it will be if you handwrite it. Even if it goes to a 3rd page, don't worry, you won't be penalized as such, because I understand that certain people will have the font of the handwriting will be different, the size of the handwriting will be different, and I will always suggest that you keep it as clean as possible, right? Have a lot of spacing in between, and even if that spacing means that you go up till the 3rd page or the 4th side, it's fine, as long as it's neat and it's clean and it's presentable. Okay, I'm not going to go through the parameters once again, but I want to take you through the brief outline. Okay, so many of you have asked me that did I practice before my exam, or did I practice any questions, or did I work on any SLPs, or how did I prepare for it? So I'm just going to take a minute to tell you that I have interned with 3 honorable High Court judges and 1 honorable Supreme Court judge, and that is where I got a lot of my exposure. And having said that, it does not mean that if you have not interned with any of the justices, you will not be able to prepare the brief, because I'm going to share the peshi that we used to make. I mean, a format of the peshi that we used to make. That's essentially what I've based my answer on. And don't worry, after this session, you'll be as good at making peshis as I was, or as any other law intern or law clerk is. So don't worry about that. Okay, so what are the contents of your brief now? What I want you to do is, I want you to remember these contents in this sequence itself. Okay, by that I mean that you have to know what is the case number and what is the name of the parties that goes on top of your peshi. I'm going to call this a peshi because I'm in a habit of calling it a peshi, but I'm actually talking about the brief. Question number 1, okay, of your part 2 of the exam. So on the peshi, when you write the peshi, on top of it, you start with the case number and name of the parties. 1. Second, you go on to relevant facts of the case. 3, you go for the judgment in challenge, under challenge, the impugned judgment or the order. Next, you write the grounds, then you write the prayers. Then you write interlocutory applications, IA applications, which are where necessary. Usually, you write them down even if it's not necessary, because that is what is prayed, right? That is what is the first matter in issue at that time. Then you have counter affidavits, rejoinder, all of that, replication, rejoinders, that, and a gist of the previous order. So I hope that you all have read the 2023 question number 1 of 2023 exam. I really hope that you all read it. And if you haven't, please read it. You can even if you've not read it, let's just go ahead. And if you have read it and if you have it at handy, just open the question paper in front of you. It will be really helpful because I'll be taking you through it, right? So this is the question number 2. I will not be focusing much on this because I really am thinking and I really hope that this is something that you can handle on your own, right? Because as I spoke about this in the previous session as well, I'm just going to quickly repeat the pointers here. This is just a draft research memo. Okay, you will be given a set of facts and you'll be given relevant judgments. Based on that set of facts, you have to suggest, you have to give your suggestions, you have to give a legal advice essentially. Right? And I've already told you that there is no right or wrong legal advice. It's only how you justify. It's how you read those judgments and incorporate it in your answer. Okay. If time permitted, we'll just go through the question paper, question 2 of 2023 also. Okay. Here also, I would suggest that you keep this outline in your mind. So how will you structure your answer in question number 2? Just keep it very brief, that you start with the heading memorandum of facts or memorandum, and then you just go on to write the brief facts, very brief. Do not write too many facts. Try to narrow down the facts in just 3 lines, not more than that. Okay, and then issue involved very clearly, make headings. When you write this answer, make a heading, brief facts, underline it, outline it. So what I did was that I took a black pen, I took a blue pen, a pencil, and a scale, a ruler, basically with me in the exam. Whatever headings that I was writing, I wrote it with a black pen. Inside all the content I wrote with a blue pen, and I was underlining things with a pencil or making lines or charts or whatever is necessary, I was doing that. So make headings. Issue involved, make a heading, write your issue. Even if, and please make sure that you don't just frame one issue, try to frame more than one issue. Okay, frame at least 2 issues. So issue 1, Roman numerals 1, and then Roman numerals 2, and write your issue point wise. Then you write the laws involved, you put down the provisions, you'll be given those provisions as well in the question paper. And you put down the law and the provisions, and then you write your discussion and your reasoning that I am applying this law to the facts like this. And then your finding and conclusion, where you state that very clearly, you will state that for issue number 1, this is how I've decided. Issue number 2, this is how I've decided. And you will be very, very clear with your reasoning. Okay. And okay. So question number 3, I hope everybody is clear. Again, you only have to do one question. Do not attempt all 5. Be very clear, okay? Don't make this mistake. Don't attempt 2. Don't attempt 3. Don't get overexcited there and think that, oh, I know everything. Oh, no. Just one. Keep in mind, just one. 75 marks, 350 to 500 words, one. And pick, whenever you're picking, pick the topic according to your concept and according to how much content you know. I'm being very practical here. Okay, you have to write at least 500 words, which makes sense, which absolutely makes sense. So don't pick any topic which you don't know a lot of content about, but you think that they will fetch more marks. Or you think that this is a more contemporary topic and this might fetch me more marks. Or don't think on the lines that, oh, everybody is going to write on this question only. I will be different and I will write on this. No. Even if you think and even if you feel you're confident and you have your content about a question which you feel everybody else may be writing, don't worry, try to present it in a nice way, right? Write a good introduction, write a good conclusion, do a good analysis, draw comparisons, give examples, do all of that. Okay. And okay, now let's talk about how to write question 1. Now you will be given a list of dates. If you have the question paper in front of you, I have my question paper in front of me. So the structure is that you're given like a front page, essentially, where it's written in the Supreme Court of India, and there is your civil appellate jurisdiction, your Supreme Court rules section and orders of that and everything. And below that, in the second headline, basically, it's written special leave petition, in the brackets civil, number 12345 of 2022. This is your case number. Okay, this is what you have to write. This is your case number. With prayer of interim relief, you don't need to write that. under Article 365, all of that you don't need to write. In the matter of, you don't need to write. Then it's simply written Shanti versus Satya and others, right? So this is your name of the party. So you will write Shanti versus Satya and others. That's it. This is your first point done. Okay. And now you have a list of dates, like an index. Next, you have an index. You don't need to go through the index too much. Then you have an office report on limitation. No need to go through that for now. Listing performer, no need. Then you have a synopsis and a list of dates. This is your main reference point while preparing a page sheet. So you go through this particular page, these two pages, very, very thoroughly, and you underline and you mark those things which have anything to do with an agreement, with a date, with a number. Okay, like a civil petition number. This case was filed on this date. It was filed. This was the result. On this date, the result came. Start underlining those things while you're reading, so that you have highlighted the part which you're going to write. Your list of dates is very important while making this. Then you're writing your applications and limitations, which was there on your page number 4, office report on limitation. This is where the limitation is provided. In this particular question, there is no previous order, application, rejoinder. But if you have those, you will add these 3 points at the very end of your answer. Okay, I'll show you my answer after this slide. And so after the,
Sorry to interrupt. I just wanted to let the students know that the link to the 2023 question paper has been given in the chat box. So if you want to follow along, you can just open that link. I just wanted to let everybody know that. Please continue.
Thank you. Thank you.
Sure.
I'll just give like 30 seconds maybe to recollect my thoughts and give everybody a time to go and click that link and open the question paper. In the meantime, I'll just tell you that I've done this session before with LiveLaw Academy, and I'm just thankful to them for the same, and we're doing this again. And don't worry, okay, I'll just take these 30 seconds to address the fact that I know I'm taking this session on 5th and your exam is on 10th. And I know that you have only a few days left. Don't worry, whatever I'm going to tell you after this is not going to affect your preparation, or it will not demand any extra effort from your end. This is just telling you a format. This is making you understand what to look for in the question paper and how to use the material given. So don't worry about that. And also, I will also like to answer that this question, address the fact that question number 1 is based on specific relief act, and specific relief act is not a part of your syllabus. You do not need to go through specific relief act. And question number 2 was based on guardianship act, and you don't need to go through guardianship act. The provisions are there. Whatever your legal understanding of these minor issues is, it will be sufficient for you to understand. Okay, so don't worry, it will not affect you. Okay, so I'll just get back to this now, and I hope that you all have the question paper with you. So you're supposed to read the lower court judgments to extract additional facts. Okay, now you've seen the question paper. You have your impugned judgment first, right? So, and then you have those lower court judgments as well. Now you might think that I'm telling you to focus on your synopsis and list of dates, which means that you don't need to go through the lower court judgment. But I'll show you how important those are and why you need to go through them, and what to look at when you're going through them. Okay, so this is my sample answer. Okay, I'll just tell you that this is a sample answer. I've tried to reproduce what I wrote in the exam as closely as I could. There may be improvements in this now, but that goes to your benefit only, whatever improvements I've made now. But I've tried to keep it the same. And yes, I did make a table. Okay, which is why I took a pencil and a ruler with me. I did make a table. SLP, as you can see, I've written SLP Civil number 123 of 2022. I've not written the whole thing again, special leave petition. No need to reproduce that. You can just straight up write SLP. That's fine. And then Shanti versus Satya and others. That's okay. In the question, it's written, others is written as OTHERS, but ORS, it's fine. You can use acceptable short forms, which everyone knows about, right? So don't worry about that. So let's everybody please come to page number 7, where synopsis and list of dates are. Okay, so now my facts, I've written a heading facts, if everybody can see, and I've divided this table such that there's a date, there are particulars, and there is a relevant page number, which is very clearly seen. When you see the sample answer, they've also written a page number, but it's after every line, which you may skip or which you may forget to write after a particular fact, which is why there's a table, so that everything that you've written can be sourced. So if you see that I've written that by agreement to sell so and so, and I've written a relevant page number 9, but I am taking you to page number 7 and not 9. I will tell you why I've done that and how is that relevant. So from page 7, my list of dates, the list of dates given in the question and my table is essentially the same. If you see, I followed the same chronology here, and I've just shortened up all the points to very, very, very limited words, and how much ever is just necessary, like absolutely necessary. And why I've written page 9 is because if you turn to page 9, it's the impugned judgment. So that is to tell the examiner that I'm actually referring to the impugned judgment and not the synopsis of date. But if I would have written page number 7 here, it wouldn't have been wrong. But I just want to have a good impression that, listen, I'm sourcing my facts out of the impugned judgment. So that's the only thing. But I don't think writing page number 7 would have been wrong. It's just what I've done. Okay. I just feel that it gives a better impression. This is just my feeling. I'm not sure whether it does or not. Okay. So next fact in the synopsis of date, list of dates, next fact is the same. It's a very, very little crux. If you read this along with me, like by agreement to sell of 85,000 paid in and possession transfer to petitioner of disputed property, plot in Monaco. Okay, so I am not describing the property, I am not describing the place, I am not saying that it was through power of attorney or anything, but it is a relevant fact later on that it was through a power of attorney, but I've not written it here because it's not necessary. What we need to tell them is what is the source of the dispute. It's an agreement to sell for 85,000 of a disputed property. That's it. Next, there was a flood, there was a reconstruction of the property, and respondent to started interfering. That's it. Very simple language, very short sentences. Nothing fancy, nothing extravagant. Next, it's the same date as provided in the list of dates, which is where I've written that this is through GPA, which is dated so and so. Now, you will, I'll tell you what is the relevance of reading these judgments right now itself. I've written through a GPA, which is a general power of attorney, which is dated 7/12/1991. Now, you cannot see this date anywhere in the list of dates, correct? This date is actually provided on page number 11, on the third para on this page, in the third line towards the end, where it is written GPA dated 07/12/1991 shows that the respondent defendant number 2. This is where I've sourced this date from, because the date is relevant. When we're telling anything or when we're writing any fact, if we can substantiate that with the date, it just makes more sense, right? So this is what I've tried to do, and this is where you reading the judgment this is why you reading the judgment is important, and these are the types of facts I want you to cull out of the judgment and incorporate that in your patient. Now, imagine so many students are writing this particular exam, and they're all writing this synopsis of dates, and everybody is going to do this, and suddenly I have another date here written. The examiner will feel that, okay, she's really, really read the impugned judgment. She has actually sourced her statements from the impugned judgment and not elsewhere. This is what stands one candidate out from the others writing, right? So, not necessarily saying that this will only be the source, but I'm just giving you tips here. Okay, anyway, let's move on. And now, here what happens is that the petitioner is going to file a civil suit against the respondent, and he will pray for permanent injunction. Okay, there's a typo here, restrain from, it's written from, please ignore that, restrain from interfering in peaceful possession. And let's go to page number 17. Okay, what is page number 17? That is the suit, that is the judgment. It's the judgment of this particular suit, where I've culled this fact from. But I've actually not done that. I've actually just copied it from the synopsis of date. Okay, and I've written a different page number. That's the only thing that I've done. I hope you can understand how I'm writing page numbers. And I've always written page numbers at the end. I'm not writing the page number side by side. I'm writing the date, I'm writing the particulars, I'm moving to the next date, the next particulars, next date, next particulars. At the very end, I will write the relevant page numbers while going through those judgments and trying to figure out more facts. I'm not writing that side by side. Okay, so now the decree comes on the 28/11/2021. 2001, I'm sorry. It comes in the favor of petitioners, right? It's decreed. Now, if you look at the list of dates, it's only written that it's a decree in favor of, it's just decreed, right? Now, when I read the judgment, when I go to page number 17, that is where I see that it's actually an ex parte decree, which becomes a relevant fact. So I have mentioned very nicely that it's an ex parte decree, and here I've just made these font bold where I feel that you need to highlight. If you I'm not sure if you can take a highlighter with you in the exam, because I haven't done that. I won't suggest you to do that because I don't know how that will work out. But just underline these important things. That it's an ex parte decree. Again, this is another point which will make you stand out from others who are just looking at the synopsis of date and not actually going to the actual judgment and seeing that what has happened. You just need to, it's a hardly 1.5 page judgment. You can just quickly read through it and just figure out that, okay, this is an ex parte. This is an ex parte judgment. You write that down. Right? This is what I want you to cull out as facts, as important things from your lower court judgments as well. Okay, why I was saying that you need to go through those judgments too. Okay, so next fact, and this is another suit that the petitioner files for specific performance of agreement to sell, and he's claiming that the sale deed which was registered. Now, if you see that I'm mentioning the dates of these deeds again and again. Agreement to sell dated so and so, registered sale deed dated so and so. Don't skip out on this. I know that it's a tedious task, it's a laborious task, but don't skip out on this. It's important. It's important to make that particular agreement to sell identified. These are the details that you need not skip on. Don't become lazy about doing this. Okay, just, I know that you will have to write the dates again and again, but do it. Okay, it's necessary because you need to make sure that the person can go back to it. Like if you see that when I say agreement to sell dated 8/8/992, and if let's say like I'm reading this specie and I forget that what happened at that date, I can just simply go to my column and look at that date. Okay, this is that date. Okay, this happened. This is the relevance of repeating the date, and this is the relevance of keeping the column of date very separate. Right? Again, registered sale date dated so and so, because here I've written dated, so you can easily refer back to that 3rd December 1997 and look at what had happened. You need not write the whole thing again. Okay, and next you can say that my page is for 470 words. This little petitioner, this got cut because of that. So it's just written that the suit on 25th, that was partly allowed. It's just a copy. I've copied from the list of dates. Okay, let's go to the next slide. I'll come back to how I've used the page numbers again at the end. I know I think I'm not being very clear about it and it may be confusing. I'll come back to it. Okay. Now the next thing happens is that the respondent is going to file an appeal and the petitioner is going to file an appeal. Now both the appeals are going to be heard by the same court. Okay, these are like, because they're coming out of the same judgment, impugned judgment. So they'll be heard together. And on the 14/11, now you see how I've highlighted only this judgment. I've only highlighted all the judgments and not the other facts where you're filing and dated. But I've written this because when you write that court set aside the judgment of 25/11/2011. Oh, I'm so sorry. Here. Okay. So when you go back, the court set aside the judgment of 25 November 2011. So I'm writing and dismissed so and so appeal, right? So now 7-8 RBT is what? You can just go back and say what is 7-8 RBT. That's the petitioner's civil appeal. That is the relevance of writing numbers in appeal numbers. You can this part is not written in the list of dates. The part where I say that as respondent number 1 is not liable to refund 85,000, this is something that I culled out of the judgment when I read the lower court judgment. Okay, and this is exactly what is needed out of you, and this is why these lower court judgments are also given, that if there's something relevant or there is something, there's some important fact, that is what you mention here, right? And then petitioner files a second appeal, and that appeal is also dismissed, and I've written in the bracket that this is the impugned judgment, because you need to make sure that you are writing very clearly that what is the impugned judgment or order. They should know that yahan se appeal aaya hai, yahan se problem source ho raha hai. I hope I'm being very clear, okay? And here I've just mentioned a series of page numbers, that from page number 9 till 12, that is the entire impugned judgment. Okay, now I've made a next heading, findings of the High Court. So I'll take you back to the, I'm so sorry. I'll take you back to this part. This. So we were talking about case number and name of parties that I've told you. Then we wrote relevant facts. Now we're writing relevant findings of the judgment or order under challenge. I'm talking about the third part now. Okay, and here, right. So findings of the High Court. Now I want you to come to page number 11 and 12. Yes, page number 11 and 12. You don't need to read the entire impugned judgment. I know I'm probably not setting a very good example by saying this, but if you are in a time crunch, you apply this only then. Otherwise, you please go through the entire judgment. But if you're in a time crunch and you're able to locate what I'm about to tell you, then this will save a lot of time. Okay, so when you go to this, on page number 11, it's the third paragraph, which starts with, after hearing learned counsels for the parties. This is your hint to tell you that after this line, whatever is written is what the High Court has observed. This is the, after this line, it's the reasoning of the High Court. After this line, it's the analysis of the High Court. Before this is only going to be a reiteration of the facts. It is only going to be a reiteration of the contentions of the parties, maybe the judgments which they've quoted. That's it. And we don't need any of those. We don't need to go through the facts again. We don't need to know what the contentions of the parties is. We don't need to see what the judgments are. So this is my suggestion to save time, is to go through the first line of each and every paragraph and to identify, okay, what may have been written in that paragraph. And as soon as you find something related to after hearing learned counsel of the parties and along and going through the documents on record and using the judgments passed in the courts below, that is your cue to tell you that's the cue to tell you that after this is the relevant part. That after this you start reading threadbare. After this is something that you will have to incorporate in your patient. So after this, what I've done is, exactly from here I started reading, and I found the general power of attorney date. I highlighted that. I incorporated that in my patient, in my point, and then I went on to the next paragraph, and this is where these grounds are written. All these 6 grounds I've actually taken out from the next paragraph, the 4th paragraph on page number 11, and from the last 3 paragraphs on page number 12. That's it. I have actually, personally, I'm telling you, I've probably not gone through the entire thing in this entirety when I was writing it while preparing the patient. So if you go through the 4th paragraph on page number 11, you'll find all these facts, but I've not written it like that. I have actually rearranged it. If you see, the way it is written in this paragraph is different, and the way I have arranged the first 3 points. So first 3 points are the same as what the points are written in this 4th paragraph. correct? But I'm not writing it just the way this is. I'm not summarizing this just as it is written. I am organizing it. That first I'm talking about agreement to sell dated, that it's a fake document. Then I'm writing that the petitioner does not have any proof of payment because the first burden of proof is on the petitioner, correct? Whereas in this paragraph, or in the question in the paragraph on page number 11, they start by writing that the respondent has failed to prove 85,000. But it's not on the respondent to prove that, right? It's not the burden on respondent first. It's first on the petitioner, which is why I'm first talking about the agreement to sell, the document on which the whole dispute is based out of. Then I'm talking about the petitioner, primary burden of proof. Then I'm talking about the respondent one, because that is what their finding is, and we're also writing that fact. We're not to judge anything. Then next, I've culled out 3 facts from here, done. After that, if you see, the next para is just a reproduction of section 20 and 21 of specific relief act, right? We don't need to go through that. No need. I've already told you, no need to write any law point at all. Then right after that, right after section 21, you have that paragraph, and the last line says that plaintiff has failed to show her ready and willingness even in the case, right? So that's the main point. In the next para is also based on readiness and willingness. That's what you write. That, and also if you, I've told you that you don't need to read specific relief act, but I'm just pointing this out here, just in case if you get a question again on specific relief act in any of the questions, that when you're attempting any question which is based on specific performance under specific relief act, one issue which must mandatorily be framed is of the petitioner's readiness and willingness, like mandatorily. Even if it is not a word, it has to be proved. You can only prove what is a word. You must frame that issue. You must answer that issue. Okay? And which is why I've incorporated it here as well. And even if you did not know this fact, I think that you could have culled this out from the judgment, because they've spent like 2 paragraphs on this, and it's sufficient enough for you to get a hint that okay, I need to write this, right? And then my next point is petitioner was never in possession of the property, which is in the second last paragraph on page number 12. And then in the last paragraph, they very clearly written that there is no substantial question of law arising. That is exactly what I've written. These are my 6 points. Apart from this part of the impugned judgment, I did not find anything very relevant to read. Okay, there's nothing relevant to get out from this judgment which you need to incorporate in the peshi. If you have time, go through the judgment. Definitely go through the judgment. It will give you more clarity of the dispute. There may have been possibility that if I would have gone through the entire judgment at that time, I might have also found more facts, more details, which I could have incorporated. But this is what I've done there. Okay. And there was something else which came up to my mind. Okay, yes. In this particular impugned judgment, para numbers were not mentioned. Okay, but otherwise, if you see all the judgments, they have para numbers as well. If possible, mention the para number as well. Like write the paragraph number also. That had there been a paragraph, let's say on page number 11, the third paragraph would have been numbered supposedly 21, for example. Okay, hypothetically 21. So I would have written agreement in point number A. I would have written agreement to sell dated 8/8/1992 is a fake document. Brackets para 21. Brackets closed. Then again in the B point, rupees